Good morning. Can everyone please hear me? Can anyone confirm if I'm audible so that we may proceed?
Please,
Michelle, please come again.
Yes, we can hear you.
Great. Good morning, everyone, and welcome to part 3 of our Hit the Ground Running series in terms of interpretation. I apologize for not being able to make it yesterday. I had some other pressing engagements that made it impossible for me to join you on the call. However, I recognize that yesterday a lot of us were in the great outside, so the numbers are not what they used to be, but would have to proceed. Yes, Fatah, please go ahead.
Yeah, hi, senior. So I'm informed that there is another class going on this morning.
Okay.
Yes, so that's a Renvoi class. So that also accounts for the low numbers. But we'll still proceed and share the recording with those who are unable to join.
It's a regular class.
I didn't hear that, please.
Is this another regular class for the part 2s or?
So no, I think it's a private class that most of the part 2s have signed on to. Yeah, so, but that's fine. We'll still continue and then share the recordings.
Right.
Cool.
So, today we are looking at the introduction to non-statutory interpretation, or the interpretation of deeds, documents, and contracts. These are documents that are not of a statutory nature, and they are documents that have acquired a certain characteristic. They have legal effect, but they were not brought into force by an act of parliament or by the enactment of a constitution. Just a minute, please. And so the goal is to try and look at what the courts have said, or the rules the courts have laid down in respect of how to approach the interpretation of such documents. It is because the interpretation of non-statutory documents is one of the most fundamental tools you need when it comes to interpretation. Now, understand interpretation like this. After you know the approaches to interpretation, the canons, the rules, you need those 3 tools in respect of 3 broad areas, i.e., the interpretation to non-statutory documents, the interpretation of acts of parliament or enactments and subsidiary legislation, and then the interpretation of a national constitution. So everything we are doing, or we have done so far, has been to lead us to a point where we are able to interpret a non-statutory document, we are able to interpret a national constitution, and we are able to interpret an enactment. So it's very important that we pay attention to that. And for non-statutory documents, our focus will be on deeds, documents, and contracts, as well as wills. And there's an entire corpus of knowledge in respect of the approach to interpreting wills. And as for wills, if you like, that is the most comprehensive part of the approach to interpretation of non-statutory documents. And that is very, very intensive. It is a lot that goes into interpreting a will, and we have a very rich jurisprudence in respect of both legislation and judicial decision making or case law that allows us to understand how to approach the interpretation of a will. And so hopefully in subsequent sessions when we are doing a recap, we would highlight some things that we need to look at. But so far, what we have done is to try and provide you with a certain sense of what the goal of interpretation is. And we provided an overview and we did a brief introspection as to the general focus of the law of interpretation class. And so that is what we spent the first day doing, following which we looked into, if you like, the approaches to interpretation. We highlighted some of the approaches and then spent some time focusing on purposivism and the modern purposive approach to interpretation, which approaches have been adopted by the Interpretation Act as the most desirable approach to interpreting an enactment or a constitution. And so those are the most formidable approaches that the courts have come to determine. And subsequently, it has also been adopted in legislation as the best view to interpreting such documents such as a constitution and enactment, which has wide legal effect. So those are the things that we spent our first 2 days looking at, and today we are going to zooming into the interpretation of non-statutory documents and the rules the courts have prescribed for us, and what those rules mean, and why we need to have a sense of those rules anytime we are seized with the question to interpret a clause, a phrase, or a word in a non-statutory document. Please, can you see my screen? Is the slide visible to all, please?
Yes, please.
Thank you. So when it comes to deeds and documents, there's something known as the Bani and Bani 3, plus what I like to call the Alan Sugar 4, or the Valco and Valco Aluminium and Boating 4. The Bani and Bani 3 are the 3 rules established by the court in the case of Bani and Bani as the basic rules of construction of deeds and documents. But by our reading of cases such as Alan Sugar Products and Ghana Export Co., Najat Metals and Hansen, and also, if you like, the case of Valco and Boating, you would come to the determination that the courts have also evolved a 4th rule, which is that the document must be read as a whole. So in Bani and Bani, the court noted that first, the construction must be as near to the mind and intention of the author as the law would permit. And second, the intention must be gathered from the written instrument itself. And third, technical words of limitation must be given their strict legal effect. And as I mentioned, the 4th rule is that the words in the document must be read as a whole, so as to arrive at the true intention of the maker of the document. It is important to note that the premise for your answering of any question that involves non-statutory interpretation is to lay down these rules. So as soon as you have identified and you come to understand how to answer interpretation questions. But as soon as you have identified that the area of law is non-statutory interpretation, or it is the interpretation of a deed, document, or a will, please, the first thing you do is to lay down these four rules and discuss them. Please, is that clear?
Yes.
So it's important to remember that anytime, as for these four rules, you have to make it your bread and butter to try and understand them and then keep them in mind. Because, I mean, you ought to be able to commit them to memory and realize that anytime you are doing a discussion on non-statutory interpretation, these four rules must necessarily be of or they must necessarily be present in your discussion. So in Bini and Bini, the settlor was the father of the plaintiff and the grandfather of the defendants. And by a deed of settlement, he decided to convey his freehold land with buildings thereon to three persons as life tenants, and thereafter to his four children as remainder men, their heirs and assigns forever. Now, this plaintiff was the sole survivor of the remainder men, and before his death, the settlor had acquired a tract of land adjoining the subject matter of the land and the settlement. And the adjoining land plus the settlement was treated as one and the same, known as Bineville. Now, the dispute had to do with the interpretation of Exhibit A, which was submitted to the court as to whether or not the settlor chose to convey the property in terminology peculiar to English law, and whether the remainder men took on the property as joint tenants or tenants in common. Because, as you know, depending on where the way in which the court viewed that particular document, it would have demonstrated the legal effect of the inheritance to the property as to whether in terms of a joint tenancy, the plaintiff as a sole surviving joint tenant becomes the absolute owner, or in terms of a tenancy in common, the heirs and assigns of the other parties also tend to benefit from that. And so that is where the court came to note that the object of all interpretation of a written instrument, like I've noted in previous sessions, is to discover. Please hold on for me just a second, please. So, apologies, but the point I was making was the court reiterated the point I've been making this whole time about the object of interpretation, which is to discover the intention of the author and the written declaration of whose mind is always considered to be. And so that is where the court decided to come up with these three basic rules for interpretation of non-statutory documents. But if you recall, these rules that I have just outlined to you, they evolved, sorry, they evolved from a particular approach to interpretation. And we have already highlighted that. Who remembers? These rules are an offshoot of a particular approach to interpretation. Who remembers that? Which particular approach is that?
Please, is it intentionalism?
Precisely. When we're discussing intentionalism, we mentioned some of these principles. And so you would find that when it comes to the construction of deeds and documents, the courts take an intentionalist approach to try and evince the meaning of the text or the subject that is the contention of debate or dispute arising out of the facts that have been presented to the court. And so now let's tear apart the various elements that the courts have outlined and try to understand what they mean. The first one is that the construction must be near to the mind and intention of the maker. In a sense, this is a reflection of the literal rule that, like I mentioned, is always the first base for any interpretation. And so the courts adopt the position that, as much as possible, we must adopt an interpretation that is near to the mind of the maker of the document to ensure that we are better reflecting his intention. So the basic or the first approach to all forms of non-statutory interpretation is attempting to find the literal meaning of the words. However, we don't stop there. If the literal meaning of the words will lead to a manifest absurdity or a repugnancy, the court can modify the literal meaning with some other meaning including the secondary meaning, and reach an interpretation that could give effect to the author's intention. But note that the court cannot get to an interpretation that would be far removed from what ought to be, have been the intention of the maker of the document. I'll take this again. What I'm saying is that when it comes to non-statutory interpretation, the first base is, in a certain sense, an admission of the relevance or the reliance on the principle of literalism, the literal rule of interpretation. And I'm saying that the court must be able to discover the true intention of the author of the document and arrive at an interpretation that gives the document its real meaning. So the principle is that the construction or the interpretation must be near to the mind and intention of the maker. So if the court finds, so the court must do this by trying to apply the meaning of the words as used in an attempt to be as near to the mind of the maker as possible. However, if the court finds that a literal meaning of the words will lead to a manifest absurdity, repugnancy, or inconsistency with the rest of the document, then the court can modify the literal meaning to avoid that absurdity. But remember the caveat that the modification of the literal meaning must be only to the extent that allows an avoidance of the absurdity. This is not a substitute, or this is not an opportunity for the judge to go on his own frolic and replace words in the document, especially when those words or the meaning ascribed to those words could not have been within the contemplation of the maker of the document at the time of making the document. Please, does this make sense?
Yes.
So if you see the case of Inri Amatefu deceased, Amatefu and Amatefu, this is a case where a testator in his will directed that 20 euros of the rents accruing from his house should be given to his wife and the balance shared among his children. Now, at the time he died, at the time of the execution of the will, the rent was about 100 euros. 26 years after he died, the rent was just about 1,500 euros. And the issue was whether the will should be strictly and literally construed as meaning that the testator intended his wife to receive only 20 euros of rent at all times, or whether it should be construed as meaning that the testator intended his wife to receive 20% of the accrued rent at all times. Now, a literal interpretation of the clause in the will will demonstrate that what the testator expressly said i.e., the maker of the will expressly said, was for his wife to receive 20 euros. And so a strict constructionist approach would have preferred that his wife receive only 20 euros. However, the court noted that the interpretation or a strict reliance on that 20 euros would lead to a manifest absurdity, and it would not stand to reason, because the times at the time the will had been made, the rent was 100 euros, and now the rent has substantially increased. And so in that instance, the court did an interpretation that brought the understanding of the euros to a percentage. So instead of saying 20 euros, the court now viewed that provision in the will as reflecting 20% of whatever was the income accruing from the rent. And so that is the position the court took in Erie Amatefiu. And that is a good example of how, even though there are clear express words used in a will, when an interpretation of those words will lead to a repugnancy or an absurdity, then we will not defer to the literal meaning, we'll apply some other meaning to allow the, if you like, the true intention of the maker of the document see the light of day. Another case you may note is also the case of Imprim and Bafo, where the testator made a direction in his will that his house should be occupied by certain specified members of his family and their children as a family house. He also noted that other members of his paternal and maternal families should also be given rooms in case they need accommodation, and the house should never be sold. Now, these directives were always followed until his executors died, and when they died, the defendant, who was the head of the testator's family, took over the management and control of the house and decided to collect rents due to the estate. It was held that, as a general rule, the expression children meant immediate descendants and did not include grandchildren. It might, however, appear on the construction of a particular will that the testator used the word children in a wider sense so as to include grandchildren and remoter issues, and this might appear in the context of the will itself. What you must note in respect of the decision in Imprim and Bafo is that sometimes the court may look at the whole context of the words used in the will to arrive at a certain conclusion, such that in this instance, if the court had strictly constructed the meaning of children as to mean direct descendants, then all the other issues, the grandchildren and all the members of his paternal and maternal families, would not have had access to the property. However, to the extent that in context of the way in which he used children, while one might come to the reasonable conclusion that he intended for other parties other than his immediate descendants to benefit from the family house, then it would be improper to apply the literal rule. And so that was the court's position in that, to the extent that the court was of the view that in that instance, the construction that would be as near to the mind and intention of the maker of that will would be one that allows other members of the family, not necessarily restricted to only the children, to benefit from that particular property at all points in time. You may also see the case of Adai and Donko, which in effect provided a contrary view as to the meaning of children in terms of the position taken by the court in Imprim and Bafo, and then come to an analysis of the two. But in sum, on the first point, when we say the construction must be near to the mind and intention of the maker, all we are saying is that the first base is to try and apply a literal meaning to the words, and the court's task is to discover the true intention of the author of the document. And so where a literal meaning of the words leads to an absurdity, then the court must apply some other meaning which saves the document. And you come to learn something in presumptions that says that an interpretation must be one that is aimed at saving or preserving the document rather than rendering it superfluous or useless. And so when you come to that, you further get the perspective I'm trying to edge on you. But what I'm saying is that The first rule allows the court to modify the literal meaning and provide some other meaning that gives effect to the intention of the maker of the document. Please, any question? Any question on the first rule, please?
Please, it's clear to us. We understand it. Thank you.
The next one is that the intention must be guarded from the four corners of the document itself. Now, the court must look at the written expression of the maker of the document to ascertain his intention. Unlike statutory documents, unlike constitutions, where we say that the written text is not exhaustive of the intention of the lawmaker, when it comes to deeds and documents, we approach it in a stricter manner by outlining that for deeds and documents and wills, you must gather the intention from the four walls or from the four corners of the document itself. And so, how do you gather the intention? Look to the written expression of the parties. What have the parties themselves written in their document? That is what will tell you is the true meaning of what they intended. So you must give effect to the intention as expressed and not what was intended to have been expressed. The court is not at liberty to think for the parties and substitute the presumed intention for an expressed intention. So expression is very important when it comes to written instruments and written documents, such that when something has been expressly stated in a written instrument, it does not lie in the mouth of the court to say, well, the parties may have intended one thing or the other. The court's duty in that instance is to exclusively look at the document and then be able to provide an interpretation or an understanding that reflects that intention as expressed by the parties. There's no presumption of intention when it comes to written documents, provided or especially, in the context of non-statutory interpretation. So if you see the case of Akim Akrosustu and others versus Akim Mansustu or Achim Mansu, depending on how you pronounce it, the plaintiffs sued the defendants for a declaration of title to a piece of land on the grounds of fraud. And in support of the alleged fraud, the parties pleaded that the family described in the conveyance as vendors never in fact existed, nor could they have been represented in the execution of the conveyance. This is what the court had to say. The court noted that what the words in a document meant can only be derived from the document itself. The intention of the parties has to be gathered from the written instrument. Now, the function of the court is to ascertain what the parties meant by the words which had been used. The court has to declare the meaning of what is written in the instrument and not what was intended to have been written so as to give effect to the intention expressed. For it is not permissible to guess at the intention of the parties and substitute the presumed intention for the intention. And since in the instant case, the plaintiffs were not parties to the conveyance complained of, their intention and presumed intention cannot be substituted for clear intention of the parties who had accepted the document as binding on them. Similarly, in Alan Sugar Limited versus Ghana Exports Company Limited, Francois J. noted that it is not the function of the court to rewrite an agreement for the parties by inserting terms that would have been beneficial but were overlooked, especially when such an interpretation would amount to an interference with a third party's bargain. And so generally, when it comes to contracts, documents, wills, we take the position that the court must look to the strict words used in the document to try and understand the intention of the parties. Resort to extraneous materials or extrinsic materials materials that are not inherent in the contract is not desirable when it comes to interpretation of a non-statutory document. Any questions?
Understood.
Okay. The next one is that technical words of limitations must be given their strict legal effect. This one we explained it the last time, but just to rehash that when a word or an expression as used by the parties has acquired a special or technical meaning, then the court must construe the word or expression in its true technical sense and not in the ordinary meaning. Now, this rule applies even if by mistake of the draftsman there's a manifest failure of intention of the testator or the maker of the document. And so, just by virtue of drafting, the maker of the document may have intended one thing, but because they used a technical word, and that technical word defeats the intention of the testator, to the extent that the technical word has achieved that status, or the word has achieved the status of a technical word, it will be given a strict technical meaning. And so terms such as assigns, the and many other examples of technical words we use would be provided their strict technical meaning to ensure that they are giving their legal effect. So the third rule when it comes to construction of deeds and documents is simply to the effect that in order to ensure that the interpretation provides a very comprehensive view of the intention of the maker of the document, we must ensure that technical words or special words that or words that have acquired a special or technical meaning are given legal effect. The final rule is that the documents must be read as a whole. It is now a basic rule of construction that in order to ascertain the true meaning of the words used in the document and to give effect to the true intentions of the maker of the document, the interpreter or the adjudicator called on to interpret the words used in the document must be able to interpret the document by reading same as a whole. Now, if you look at the case of Boating against Volta Aluminium Company, the court noted that the language used and all the clauses should be looked at as a whole, and every clause compared with each other to make sense out of them in order to discover the true intention of the parties. And also in Menu and Emira, the court also noted that if on consideration of the whole document, there are grounds appearing on the face of the document affording proof of the real intention of the parties, then that intention ought to prevail against the obvious and ordinary meaning of the words. Finally, in Najat Metal Enterprises Limited and Hansen, the court noted that the rule that the document must be read as a whole to determine the true intention of the maker becomes relevant, especially when there's an apparent mistake in the reading of the document. And so, by the basic rules of construction, we are encouraged to read the document as a whole and ensure that we have a holistic view or a holistic perspective, because the documents or the words in the documents, like we mentioned the last time, do not sit in a vacuum. They must come together to form a certain narrative or make sense. And the way in which we are better able to position ourselves to provide that understanding or making sense is to allow for just a second is to allow for a holistic reading of the document. And so that is the position established in both Boating and Volta Aluminium Company and those other cases I've mentioned to you. These are the Binding and Binding 3+1 that form the basic rules of interpretation of non-statutory documents. Any questions?
Hello.
Yes, please.
Could you please clarify the first rule, that is, construction must be near to the intention, and then when it may lead to absurdity, you can modify it. However, in the second rule, it's saying that intention must be guarded and it must not go beyond the four corners.
Mhm.
Does it therefore mean that if the second rule may lead to absurdity, will still remain in the confines of the document?
So, okay, please take your question again. I like the way you phrased it. Just take it again so that everybody is.
I have forgotten it.
Try.
Okay, so I was saying that the first rule was that the construction must be near to the intention of the maker. And if
Mhm.
however it will lead to absurdity or repugnancy, then you modify to make it as near as possible. That was if I get it right.
Yes.
The second rule was that the intention must be gathered from the four corners of the document. So my question then is that, assuming the second one may result in absurdity or repugnancy,
Mhm.
can we go out of the document to ascertain the intention? Because you said that the approach is much stricter.
Mhm.
Mm,
Okay. So here's understand it this way.
okay.
When you're applying the binding and binding rules, it's not like you go from one to the other. The It's not the way in which they are provided is not necessarily a chronology. What in effect they are, if you like, binding rules in respect of approaching statutory interpretation. But when we say the intention must be gathered from the four corners of the document itself, what we are suggesting is that the adjudicator does not have the power to presume an intention that is not apparent on the face of the document. Understand it this way. We are saying that the construction must be near to the mind and intention of the maker as possible. That means that any interpretation you make must give effect to the intention of the maker. And how do you find the intention of the maker? So after you are mindful of the fact that you must make an interpretation that is near to the mind of the intention of the maker, then you come to the understanding also that to be able to discover that intention, look to the written text itself. Do not impose an intention or presume an intention that is not apparent on the face of the written text. And so, in a sense, you go back to, so you start from one. One tells me that, okay, this interpretation I'm doing, I should be able to do it to make it as close to the mind of the maker as possible. That's fair. Two tells me that if I want to understand the intention of the maker, I should look at the written expressions of the maker. I shouldn't go outside the document to try and understand what he meant, i.e., I should not presume any intention. When I've understood that I need to refer to the document itself, I go back to one and I say that, well, but if there are any words used that would lead to, or any words used that a literal understanding or a literal application will lead to a manifest absurdity, repugnancy, or inconsistency with the rest of the document, then I will choose some other meaning. So a secondary meaning or a fringe meaning, some other meaning that will take me back to two, i.e., allow me to express the intention as provided for from the written document itself. I'll give you an example. Now, in re amate few, in that instance, the intention of the testator was gathered from the document itself. What was the intention? His intention was to give some money to his wife, accruing in terms of the monies that have accrued from his rent. He provided a certain amount, which is 20 euros. So the court did not go document that when we know that men like to provide evidence of everyone, the court exclusively limited itself to the will the face on the will as had been provided it, and said that okay, the intention of the testator was to give his wife a certain amount of money. From where? From the rents accruing, or from the money accruing from the rental of his property. That was number 2. But then they went back to number 1 and said, however, if his intention was to give somebody money, if his intention was to give the wife money out of the rent, is it proper to assume, or is it proper to say that he intended only 20 euros, especially when at the time of the execution of the will, the amount was 100 euros? Or you can make an analysis that suggests that, well, based on the prevailing circumstances, he intended to have given a certain percentage. Instead of a set figure, he intended to have given a certain percentage. Because 20 euros, as at the time, 26 years after the coming into force, or after the execution of the will, was immaterial within the context of what was intended by the maker. So if he was willing to give his wife 20 euros when the rent was 100 euros, then it would better reflect his intention if we're able to make an analysis or provide some other meaning rather than a literal meaning that ensures that we are giving effect to his wishes to give a certain percentage or a certain amount of money to his wife, especially out of the proceeds of the rent or the rental of his property. And so that is a very good example of how you do the back and forth. You come on the premise that the construction must be near to the mind of the maker as possible, but you also note that you must look to the document itself to find his intention. Once you have found his intention, go back and interpret the document and ensure that the interpretation of the document is as near to that intention as possible. However, if so you start that by trying a literal meaning of the words. If a literal meaning of the words will lead to a manifest absurdity or a repugnancy, then you can dovetail into some other meaning. But that some other meaning must go back to the same point in 2. And that some other meaning must reflect the general goal of interpretation, which is to give effect to the intention of the maker of the document. Ira, I hope this makes sense.
Oh, very well. Thank you. And I thought it was chronologically, but I now get it much better. Thank you so much.
Right. Any other questions, please? Any other questions? Okay, just a few things to note. Now, where in a written agreement, clauses are incorporated by reference, and they are in conflict with the clauses in the agreement, sorry. The ones made by reference in the written agreement takes precedence over the clauses in the deed itself. Does this make sense?
No, please, not quite clear.
Okay. Sometimes we can make, so oftentimes, especially in large transactions, contracts, and certain type of, especially construction contracts, or even in Wales, in order not to make the documents bulky, we incorporate clauses by reference. Now, incorporation of a clause by reference is simply the process of making a document as part of another document by referring to the first document in the latter. So you just make a declaration. So let's assume, let's make it more practical. There's a road contract. There's a contract for the construction of a road, and you want to incorporate what is known as the FIDIC. I don't know if anybody knows what the FDIC is. But they are general terms of contracts, right? and let's say you want to incorporate some general terms of the contract without necessarily stating each of them. And so you are making reference to that document, right? And you are saying that that document should be incorporated into your contract. So in the contract, you would say that the provisions in the FEDEC are hereby incorporated. So you make a declaration that that document, which is not necessarily attached as part of the contract, is hereby incorporated in the contract. It allows for the contract to not necessarily be bulky, it saves space, and ensures that the incorporated document also forms part of the binding nature of the contract. And we are saying that when it comes to incorporation by reference, when there's a conflict between the clauses of the agreement and the one made by reference in the written agreement, the clauses incorporated by reference will take precedence over the clauses in the deed itself. Does this make sense?
Yes.
But why?
The idea is that when it comes to clauses incorporated by reference, they are assumed to be standard form clauses that are usually commonplace in the particular industry. And so they are not subject to a lot of modifications. And the idea is also that once the parties have decided to incorporate them by reference into the contract, the parties are fully aware of the terms therein. And so just by that incorporation, they have taken a manner, or they've taken a position that is, if you like, on top of the clauses in the deed itself. So when there's a repugnancy between the clauses in the deed and the clauses in the incorporated document, we say that the incorporated document should take precedence. Kojo, your hand is up. Kojo, please go ahead.
Hello?
Yes.
Yes, I wanted to find out, when you make a reference to a certain document, yes, it contains, like, for example, the FIDIC that you mentioned, it contains several things. And to read it, the two parties may at a point say they probably don't know, but they can just reference it and know what exactly it is. But if they have specifically written things in their contract, which that's one they know, let's say there are 3 items, they have mentioned 1, 2, 3. Is it possible, or is it reasonable to say that the things that they are specifically written, which are just a few things, 1, 2, 3, another thing that they have reference to, which are several, which until they have referred to, they probably don't even know or recognize it? That one, that referred document, would rather take precedence on the few things that they've intentionally written inside the deed. I find it difficult to appreciate that.
Yes, I see the tangent you're going on. It's something that we'll talk about when it comes to statutory interpretation, where when there are specific legislation in respect of a matter, that specific legislation must be deferred to the exclusion of the general legislation. So when the parties have specifically provided for certain terms in their contracts themselves in relation of 1 or 2 matters, you are indicating that it may be unfair that the general provisions on the incorporated documents should be allowed to apply. That is why parties must be very careful on the incorporation of these clauses, because the idea behind incorporation by reference is such that it provides, in a certain sense, it makes that document now binding as part of the contract. But also, when the document is incorporated, especially when you've decided to fully incorporate the document without any exclusions. You are wholly importing the clauses, and the positions the courts have taken in respect of incorporation by reference clauses is that to the extent that they are inconsistent with the clauses in the deed itself, they will allow the incorporated documents to prevail. And like you mentioned, and like I've mentioned early on, it arises out of the technical nature of many of these clauses. And the courts would often presume that by making, sorry, by taking the decision to incorporate by reference these documents, the parties intended that the clauses in the incorporated document ought to take effect over even their own express written agreement. So parties should be mindful when it comes to incorporation of documents. And that's something that we should be very, understanding of. The next thing is that in the case of recitals, the law is that the operative parts of the deed, which are clear, cannot be controlled by the recitals. However, where the ambiguity is in the operative part of the document, the recitals may be consulted to clear the ambiguity. I'm sure you have seen multiple contracts where the contract begins with whereas and provides, if you like, a certain narrative that establishes the basis for the agreement. And so it allows the court understand, or it allows anybody who takes the contract to understand on what basis the contract was entered into in the first place. These are known as recitals, and you come to learn about narrative recitals and their effect on the legal documents, be it a statute or a contract. We are saying that when there's no ambiguity in the operative part, when we say a part of a document is operative, it means that is the part of the document that is binding, or that is the part of the document that has legal effect. And we're saying that when the operative part, such as the clauses of the contract itself, are clear and unambiguous, we will not refer to the recital to provide us an understanding of what the provisions mean. However, when there's an ambiguity and the recitals will help us to resolve that ambiguity, we may defer to the recitals to enable us better understand what the intention of the drafter of the document was. So we also need to pay attention to that. Now, where a printed contract is superadded with writing and there's ambiguity, the written words will prevail over the printed one. This is an old position of law, but it continues to remain as part of our understanding of interpretation, that where a contract which is printed has been supplemented with writing and executed by the parties, and there's ambiguity or there's an inconsistency between the written words and the printed words, the court would prefer to give precedence to the written words over the printed ones. Next, draft copies of documents are inadmissible to interpret that document. Now, especially where the document is entirely different from the draft, the courts cannot use the draft to construe the deed. Who can tell me why this is a thing? Why do we say we will not allow draft copies to be used in interpreting the meaning of the words used in a deed or a document? Any ideas?
It's okay. Keep quiet. So, sorry, okay. It's okay, sorry.
Please, any ideas? Why are we saying that draft copies are inadmissible to interpret a contract or deed?
Hello.
Yes, please.
Hello?
I want to believe that because to avoid the para evidence rule, to give effect to the para evidence rule.
Your answer is hanging. Please tie it in.
Hello, can you hear me?
Okay.
Yes, but Kofi was making a point.
Evidence, the para evidence rule, that whatever the intentions prior to the sign of, for instance, the contract should be reduced into writing. And once that is done, all prior agreements or negotiations will not be imported when construing the document.
Precisely. Nice attempt, Kofi. Thank you very much. Kojo, do you have something else you want to add on?
Yeah, I was saying that. Can you hear me?
Yes, please.
I was saying that draft is drafts, and the use of drafts implies that there's probably a room for further negotiation. It is not finalized. So until it is finalized in that proper sense, that could not be construed as the final intentions of the parties to bind themselves in any particular endeavor. So we could not use that as a conclusive document to interpret the deed. It's still open.
Okay. That is also a very good perspective. But I want somebody to answer this question on the basis of one of the rules that we have discussed. Look at the rules that we have discussed in Binding and Binding plus Boatin and Walter Aluminium. Which of the rules would be able to provide a basis for us to say that we will not use draft of these to interpret a contract? Nobody. What is the second rule of construction in Binding and Binding?
The intention must be gathered from the four corners.
Okay. You see how this is relevant then?
Yes, from the document.
Great, thank you. Now, finally, written words normally prevail over figures where there's a discrepancy, between the words and the figures. This one, I'm sure by now we all know this. When there's an inconsistency between words and figures, even on negotiable instruments, usually we defer to the words over the figures. So this one is fairly straightforward. Please, any questions? Right. Just to clarify, have you begun your discussions on the interpretation of wills? In class, that is.
I think we've done construction of wills.
Yes.
Okay, then we can proceed. Thank you. Okay. Let's look at construction of wills briefly. And I mean, oftentimes the non-statutory interpretation question is on a will. Oftentimes, more often than not. It is very rare for you to be called on to interpret a deed or a document. Oftentimes, when it comes to non-statutory interpretation, the focus is on wills. So we'll spend some time on that. Now, you have studied a bit of wills in the law of equity and succession. And you know that in Ghana, the wills or the making of wills is governed by the Wills Act 1971, Act 360. And generally, a will is a voluntary disposition, and it is one made to provide for the distribution of a person's estate on his demise. And the rules governing wills ensure that the making of a will is the exclusive preserve of a person who is 18 years and above, and he must do so in writing and in accordance with the act, and he can make a will disposing of his property, which is theirs or which is his at the time of the making of his will, the property he'll be entitled to at the time of his death, and property he may be entitled to after his death. These are three main areas that a will may cover: property you have at the time of making of the will, property you may have at the time of your death, and property you would have after, or property that will devolve onto you after your death. Now, generally, the courts adopt, like I said, just like contracts and deeds and other documents, the courts adopt a very restrictive approach to interpretation of a will. And the court does generally refrains from interfering with the intentions of the testator. It is only under certain circumstances that the court would willingly interfere with the intention of a testator. Who can tell me what that circumstances, or what an example of that circumstance would be? I'm saying that the courts refrain from interfering with the wishes of the testator. And that we use the testator here to mean the person who made the will. And I'm saying it's only under extreme circumstances, or only under certain situations, that the court would interfere with the provisions of the will, and, if you like, alter the true intentions of the testator. Who can tell me one? Or who can tell me what it is, per se?
I think, if I remember, some ambiguity and some the armchair rule.
Okay. That is not. So in that instance, the court is going through a process of interpreting the provisions of the will. It is not necessarily disturbing the provisions of the will. I want an instance where the court would actually disturb the provisions of the will and say that, even though you didn't do this, we are doing this. Even though you didn't make any, if I say that, I would answer the question. So let me hold on. Edison.
When a reasonable provision was not made in the world for
yes,
a parent, a child who is under age, and a spouse,
yes.
Either during the lifetime of the testator or in the will itself.
Exactly. Yes. So under Article 22(1) of our Constitution, of our national Constitution, and Section 13 of the Wills Act, the courts can disturb the provisions of the will when the testator does not make reasonable provision, whether on his life, whether in life or by his will, for the maintenance of his parents, a spouse, or a child under the age of 18 years. And so it goes back to the point I was making a little while ago, that the courts will generally not interfere with the provisions of the will. They will only do so under these statutory conditions. Now, when we look at a will, we say a will is ambulatory in nature. Now we are going on to look at the characteristics of a will. We say the will is ambulatory in nature. What does it mean to say a will is ambulatory?
It takes effect upon the death of the testator.
Great. So what it means is that the will is merely a declaration of intent. It is merely a declaration of intent and has no effect until the testator is dead. So during the lifetime of the testator, he is free to deal with his or her property as and how she pleases. So you cannot say that, oh, Daddy, you've made a will for me, that you give me your car, but you are driving the car too much. You spoil the car before you die. That doesn't arise. So because a will is ambulatory and is a mere declaration of intent, the testator has the power to deal with the property up until the point of his death. And we also have to remember that the will is revocable at will. The testamentary disposition can be revoked at any time by the testator by complying with the provisions of the Wills Act. I'm sure you are well aware that there are certain instances where a testator may have purported to have revoked his will, but because he did not comply with the provisions of the Wills Act, that revocation has no effect. And so the testator can at any time revoke his will, and he cannot even enter into a contract not to revoke his will. That is also very important. Remember that by virtue of the provisions of section of the Wills Act, a testator can only dispose of self-acquired property or property that belongs to him. Family property, property held in trust cannot be the subject of a disposition in a will. So those are some of the characteristics of a will. The fact that it's ambulatory, the fact that it's revocable, the fact that it relates to self-acquired property. These are all things that we look at when we talk about the characteristics of a will. The next thing we talk about is the capacity to make a will. And I've mentioned this briefly. I said that under section 1 of Act 360, the first principle is that you must be of 18 years and above. But next to, you must not be suffering from any insanity or infirmity of mind at the time of making the will, so as to be incapable of understanding the nature and effect of the will. Testamentary capacity is very important when it comes to the making of a will. In fact, many of the conflicts we have in terms of wills arise out of the fact that people question the testamentary capacity or the mental capacity of the persons who have made a will. And so at all points in time, it's important that you're able to establish in your interpretation that the person had capacity to do the thing. Let me explain. When you're answering a will-based question, a question on the interpretation of wills, you'll be very surprised the nature of things that you have to discuss, because you have to start your discussion from, first of all, what is a will? Then you go into who has capacity to make a will. Under what circumstances can a person be said not to have capacity to make a will? There's a whole body of discussion, because the understanding you must be able to establish in your answer to that question is that, first of all, was the will validly made? So before you go on to interpret the contentious provision in the will, you must be able to establish beyond a certain doubt that the will was validly made. Because if the will lacks, if you like, formal and essential validity, what are you interpreting? So the basis of your interpretation must be able to demonstrate an understanding of the process of making a will in Ghana, and instances that will render the will invalid, and instances that will clothe the will with formal and essential validity, before you dovetail into your answer of the question. So please, at this point in time, when you are studying wills in terms of interpretation of wills, and you are seeing things such as section 1, cat rights and cat rights, capacity to make a will, formal validity, essential validity, execution of a will, the things such as jurat and all of those things, it may be like, Charlie, what's the point of all this? We studied this in the law of succession. But in answering your question on wills, the marking scheme anticipates and expects you to provide that discussion before you go into the interpretation. So you will find that the interpretation side of things, that out of the 25 marks, the interpretation that you have to do will be about 7 or 8 marks. The bulk of the marks is in the discussion on the capacity to make a will, the nature of a will, and the formal and essential validity. So please pay attention to those things and do not say that they are merely incidentals to your understanding of interpretation of wills. Because the interpretation of wills, the rules that apply in binding and binding are the same things that you come and apply here, subject, of course, to certain modifications, like I think someone mentioned much earlier. For instance, applying the armchair rule and those other rules, the falsa demonstratio rule and things like that. But generally, the binding and binding rules apply. So if you get a question on interpretation of wills and go and put down your binding and binding 3+1, and then say that, okay, I'm proceeding to interpret, I've answered the question, that would not be the appropriate way to answer the question. So you need to pay attention to that. Please, I hope that is clear.
Yes.
Hello, Joe.
Yes, Kojo.
Yes, I know you don't do the marking scheme, but I find that scheme that you are suggesting a bit problematic, because you remember in criminal procedure, yes, in the criminal procedure, even though you take a lot of things from criminal law, the most part is about the procedure. You need to demonstrate your understanding of procedure, not criminal law per se. So if in an interpretation marking scheme, a chunk of the marks is put to succession and the interpretation part is just little, I find it a bit problematic. What do you think?
I mean, like you said, I don't make the marking scheme, so I don't have a view. Mine is just to share with you. But I also think that, see, I think it's also important to be able to exhaust that discussion, because before you proceed to interpret any document, you must be able to demonstrate that the document is valid, especially when it is not an enactment or a constitution. You must come from a certain premise, because oftentimes, like I mentioned, there's also a contest as to the validity of the will. So you must exhaust that discussion first and be able to show that the document you are proceeding to interpret is a valid document, and then proceed to do the interpretation. As to the allocation of marks, I'm not in a position to speak to that, but I think that that wholesome discussion is also important because it grounds your interpretation of the words used in a particular context and gives it a certain impetus, if you like, because then you are sure that once you have interpreted the words used, there's no contest as to the validity of the will. But if you proceed on the frolic of your own and go and do an interpretation, which invariably comes back to a point where the will in and of itself is invalid, then that's problematic. And so that understanding or that knowledge of your law of succession is important. In any case, interpretation is one of those courses that you need to bring your knowledge from jurisprudence, from constitutional law, from equity and succession, and all the other, because interpretation of itself is not a standalone. Oftentimes, it is a substantive law matter that has arisen that you are proceeding to interpret. And so your basics in terms of substantive law still ought to be firm and proper. In any case, I mean, these are things that if you set your mind to, they are things that you have done before. So it's just a revision. All I'm saying is that make sure to incorporate it properly in your answer and spend some time looking at the marking schemes. You see what they require of you.
Telfer.
Yes.
Yes, I think what you are saying is right, because I quite remember in our class, Justice Chebafor's class, with the interpretation of wills, we took time and went through the Wills Act, sections by sections, trying to understand what the requirement as far as the making of wills is concerned, its execution. I think we even went through step by step to even to section 13, where he drummed home the very fact that we need to, that is the only provision aside Article 22 to where the court inserts some kind of like a disposition for those persons who needed a reasonable provision by fulfilling certain requirements. And I quite also remember in class when we are solving a particular question, he tries to lay down the basic rules before we jump into answering, providing the solution in terms of interpretation to the problem in the set of facts. And so what you are saying is right. We need to make sure we lay down the grounds about what's expected in terms of will before we identify the issue. And moreover, I think this time around we have also been told that the IRAC system for part 2 will not be encouraged. So most of the problem-based questions would have an essay type of answer where you write it in an essay form by addressing the various subjects in the IRAC format. So I think what you are saying is what we need to adopt. Thank you.
Yeah, thank you for that. And I'll just clarify a bit on the way you're expected to answer problem questions in part 2, especially interpretation questions. The interpretation lecturers have a different view on how to do your IRAC. They don't like the whole regimented area of law, issues, rule, application, conclusion. They like a more narrative, like Tommy said, a more narrative format. It's not necessarily is not entirely different. I mean, the way in which you structure the essay, quote and unquote, is also in the IRAC format. But honestly, that is a problem that we have further down the lane. You need to be able to write the exam in the first place before we even look at the technicalities of it. So, I mean, spend some time to pore over the provisions of the Wills Act. Look at Section 1, Section 2. But there are just a few things that I want to draw your attention to in terms of the Wills Act, and then we can proceed. Somebody should please read Section 7 for me. Section 7.7. Section 7.7 of Act 360. Oh, nobody.
Okay, I read. Where a testator and a beneficiary under his will die in circumstances in which it appears that their deaths were simultaneous, or B, rendering it uncertain which of them survived the other, affecting the entitlement to property under the will of that testator. But for the purposes of the entitlement of such testator to that property, under any will of the aforementioned beneficiary, that beneficiary shall be deemed to have survived the aforementioned testator, unless a contrary intention appears from the will.
I think we lost you there.
It could have been due to network because I'm done reading it. Except
Okay.
I want me to go over again.
Yes, please, please.
All right. So Section 7. Where a testator and a beneficiary under his will die in circumstances A, in which it appears that their deaths were simultaneous, or B, rendering it uncertain which of them survived the other, the beneficiary shall be deemed to have survived the testator for all purposes affecting the entitlement to property under the will of that testator. But for the purposes of the entitlement of such testator to that property, under any will of the aforementioned beneficiary, that beneficiary shall be deemed to have survived the aforementioned testator, unless a contrary intention appears from the will.
Okay, so you may recall the Comorientes rule as established in Section 34 of NRCD 323 Evidence Act, which provides that where two or more persons die in circumstances in which it makes it impossible or uncertain to determine who survived the other, for the purposes of succession, the younger is presumed to have survived the older. When it comes to wills, just a second, please. Yes, so as I was saying, when it comes to the Wills Act, it takes a different position. The Wills Act outlines that under Section 7.7, where a testator and a beneficiary under a will die in circumstances where we are unable to ascertain who survived the other, and it was simultaneous, the beneficiary shall be deemed to have survived the testator. It doesn't matter if the beneficiary was the younger or the older, as established in Section 34 of the NRCD 323. When it comes to wills, the beneficiary and testator die simultaneously, and we are uncertain who survived the other. We always assume, or it's always presumed, that the testator died before the beneficiary, and so the beneficiary will be entitled to benefit from the estate. The effect of this is that the disposition made to the beneficiary would not lapse, to go to his estate, and then when that happens, whoever is his beneficiary, so the beneficiary of the beneficiary, would now benefit from the original disposition made to the first beneficiary. Does that make sense?
Yes.
Any questions or clarification?
Yes, Joel.
Yes, Tommy.
My challenge was to the second aspect of the section 7.7, where in this case the beneficiary has made the will disposing some part of his property to the testator. And the act continues to say that, I stand to be corrected if I'm right, that even in that circumstances, it is even deemed that the beneficiary still survived the testator. Is it to suggest that? Okay, I don't understand though. Okay, I'm making a mistake. So at the point of the beneficiary making his will, the beneficiary becomes
the testator.
Okay. So I was having difficulty in constructing it.
Okay.
All right, I understand now. Okay.
Any questions? So the commemorators. Yes. Go ahead.
So I had a question earlier on the fact that the testator can only dispose of property that he has personally acquired. So that means does that mean that if he has a property that is jointly owned, he cannot put that in his will?
So it depends on the nature of the property and his interest in the property. If it's a joint tenancy, as you are aware, because of the principles of joint tenancy, the testator does not have the power to do that. But if his interest is a tenancy in common, he can devolve his interest in that property to his beneficiary. Does that make sense?
Yes. But what about that is for immovable property? What about property that is jointly owned that we cannot divide?
So what you do is, so usually when you are conveyancing, so you do conveyancing of drafting of wills. So what you do is you just convey his interest in the property.
Okay.
Whatever
just his interest. So
yes,
let's say something that it's costing, let's say 50,000. So his interest is maybe 25,000.
Yes.
Or something like
so
that.
His interest will devolve. So if they want to sell off the property and then decide to distribute the money, whatever money that comes off, if he's a 50% owner, that interest will go to the whoever his beneficiary is.
That is fair, but you see, I find it a bit challenging. You see, if let's say you and I owe an Uber vehicle that we'll be using for Uber, okay, and another puts in his will his interest in it. The other part is not interested in just getting half of the cost of the car, but he wants a continuous business. Now one of them is dead, and he says that his interest, so suddenly the thing has to be sold, and then he's given half of the money.
Okay, so I see the practical difficulty with that, but ultimately it comes back to the same thing. What was the arrangement between the parties? So say for instance, you and I, we decide to go into like you said, an Uber business, and we are equal, we have equal shares. So if we own it 50-50. And I mean, I don't want to say you will die or I will die, but you get the point. One of us passes away.
Joe, it's likely you will die. It's very likely. It's very likely.
Please. So one of us passes away, and the other decides that they want to proceed with the business. And so my family, I decide I want to proceed, but your family people say no. Once you are no more there, they want to cut all ties with me. Then that becomes an issue, that we are going into realms of civil procedure and the estate and things such as that. Those are technical issues. I don't think that I understand the practical implications of that, but the position of the law is simply that you can devolve your interest, and once you have devolved your interest, the person replaces you. So to now become a matter of agreement between you and the other party, and if you're unable to reconcile your differences, obviously there's an action, there's a course of action available for you in the courts of law that would enable you deal with the matters. I want you to particularly pay attention to the presence or absence of jurat and the effect of saying. What is the position of Ghanaian law now on the presence or absence of a jurat? You are experts in the law of evidence, so please, what is the um, position of of Ghana law now when it comes to the presence or absence of a jurat?
Telfer.
Yes.
Okay, so what I know about the jurat is that the Wills Act requires that when you are dealing with a blind or an illiterate person, there is the need for a jurat. But the question is, where there is a failure of a jurat, does it invalidate the whole will? And that is what the courts have pronounced on. And the current position is that it does not necessarily invalidate the will, if only it can be proven that indeed the said content of the will was read to the person with incapacity, the illiterate or the blind person, and he was presumed to have really understood the content of what was read to him, and he executed same. Then even though there is no jurat, and if it can be proven, it will be sustainable. The
Okay.
whole essence of it is that the court do not want persons with such incapacity to kind of use the jurat as a cloak to avoid some liability, even when they know that everything was done and they agreed and executed. Because there hadn't been a jurat, they kind of rely on it to avoid any kind of liability. And so I think the case of is this Segbeji,
Zabrama and Segbeji.
Zabrama, the court talked about the fact that where people try to use it as a cloak to defraud. So the current position of the law is that you can have a will without a jurat, if only you can prove that indeed, despite the failure of a jurat, the said content was read to the person with incapacity and he presumed to have finally understood it before execution.
Okay. Charlie, Tommy, you are ready for the exam. You can go and sleep. Anyway, so that is something that you must also pay attention to. Please. Yes, Mr. Richard.
Yeah, thank you. I appreciate the thoughts shared by my colleague. And the only thing I want to add is that the cases that have been referred to us in class, Zabrama and Segbeji and Adomaku, Dodo and Adomaku, those cases are cases in respect of conveyancing contracts specifically. And so when you want authorities in respect of wills on people who were blind and or incapacitated in some way, the best cases to rely on would be Baxmati against Baxmati, and then Christian and Inchifo. In those cases, the court were very unanimous to the extent that where on they tried to distinguish that in the absence of a jurat, on the face of the document that is to be interpreted, that is the will, the court should be able to come to the conclusion that the testator had knowledge of the document he is executing. And so if on the face of the document they are able to come to the conclusion that the testator had actual knowledge of the document he is executing, then the court will actually admit it to probate and then grant the probate to the administrators. So when you look at the case of Christian and Inchifu, the man was blind, and that was even accepted in court. It was found as a fact in court. But the dispositions made by the blind testator, the court found that it was so explicit that unless himself, nobody who even was acquainted with his life will make such dispositions. And so on the face of the will, it was found that it was the testator himself that executed that document, even in the absence of the jurat. And so it was admitted to probate. The same was with the case of Baksmati and Baksmati. He was paralyzed in both legs, but it was found as a fact that he could make use of his hands. And that before he died, and at the time that he made his will, he was totally blind. He could not see anything. And so he caused, he gave instruction to the wife, who conveyed that instruction to his counsel to prepare the will. And when the will was completed, it was read to him, and he accepted that, yes, that is what he wanted. And then his hand was guided to a place where he should sign, and he signed. And later, it was challenged that he did not have the capacity because of his blindness and the fact that he was paralyzed. The court disagreed and said that on the face of the document, it can be deduced that the man knew the content of what he was executing, and he actually executed it. And so the fact that he was blind and in the absence of the jurat was not enough to, as it is, say that the will was invalid. And so it was admitted to probate. So personally, I have challenge with the cases of Zabrama and Segbeji, and then Jodu and Adomako, because specifically those ones were speaking to contracts in relation to conveyance in land cases. But when you want authorities in respect of wills, then I think we need to limit ourselves to Baksmati against Baksmati, and then Christian and Inchifu. Thank you very much. That's all I want to add.
All right. Thank you so much, Anim.
I see your point, and thank you for the contribution. But I just need to clarify that the requirement for jurat is one that is born out of the Illiterate Protection Ordinance and the CI 47, the Civil Procedure Rules. And they apply in respect of any document involving, so be it a contract or a will, any document that involves an illiterate person. There's a requirement for the document to be read over and explained to the illiterate person. And so even though I get your point about the more specificity in terms of wills and others, a discussion on Zabrama and Zekbeji and Dodo and others would not be out of place. In fact, I encourage it when you are doing your discussion on jurat in respect of wills as well. It's not entirely out of place. Anyway, having said that, I encourage you to read the case of Kwako and Teria. This is a very interesting case that has had, like, multiple times there have been questions around it. So please spend some time to read Kwako and Teria. It establishes the provisions when it comes to the interpretation of wills and some other nuance that must be added onto it, and spend some time, of course, poring over the provisions in the Wills Act. Also look at Wilberforce and Wilberforce as well. Also very helpful in your understanding of the position that we take when it comes to wills. Hopefully the next time we meet, we'll spend some time in attempting to answer a question on wills. But in the absence of any other questions, I would leave you to enjoy the rest of your Saturday, and thank you especially for joining me for these last few days, and for bearing with us for our inability to meet yesterday. And I would like to say thank you, and I wish you all the very best in the coming year. I hope that this is your core year, and I hope that everybody's called to the bar, and great things happen to you in the coming year. So thank you very much, and
Thank
all
you
the very
so
best.
much, Telfer.
Thank you so much. God bless Mama. And
Thank you. And Happy New
Thank you,
Year.
Senior.
Thank you.
Yes.